Social media is buzzing with adoption posts, but trust me, not even half of it is true. As 80% of these posts are just hearsay, and many people fall for these lucrative posters. Hi, I'm Advocate Swapna Kode, and today, in a nutshell, I am going to discuss the adoption laws available in India. Adoption is a process of establishing a parent-child relationship between those who are not related by birth. Adoption is only valid when done by following the complete legal course, and hence it is necessary to understand the meaning of adoption. In India, adoption is defined under Section 2AA of the Juvenile Justice Care and Protection of Children Act 2006 as the process through which the adopted child is permanently separated from his biological parent and becomes the legitimate child of his adoptive parents with all rights, privileges, and responsibilities that are attached to the relationship. So, who is allowed to adopt a child in India? In India, an Indian, whether he is married or single, non-resident India, that is an NRI, or a person belonging to any nationality, that is foreigner, may adopt a child. The guidelines and documentation process for each group of adoptive parents may differ. Under the Hindu Adoptions and Maintenance Act 1956, following category of people can make adoptions. Any male Hindu, including Buddhist, Jain or Sikh by religion, who is of sound mind, not a minor, is eligible to adopt a son or a daughter. But if such a male has a spouse at the time of adoption, then he has to adopt a child only with the consent of his wife. Females. Any female Hindu, including Buddhist, Jain or Sikh by religion, who is not married, or if married, whose husband is not alive, or her marriage has been dissolved, or her husband has been declared incompetent by the court, has the capacity to adopt a son or daughter in adoption. If such female has a spouse at that time and the marriage is in subsistence, then she has to adopt by the consent of her husband. Conditions for adoption by Hindu couples or a single parent. In case of adoption of a son, there should not be any living son in the succeeding 3 generations of the party, whether legitimate or by adoption at the time of adoption. In case of adoption of a daughter, they should not have any daughter or son's daughter at the time of adoption. Where there is an adoption of a daughter by a male, then the adoptive father should be at least 21 years older than the child. Where there is an adoption of a son by a female, then the adoptive mother should be at least 21 years older than the child. Personal laws of Muslim, Christians, Parsis and Jews do not recognize complete adoption. So if a person belonging to such religion has a desire to adopt a child, then he or she can take the guardianship of a child under Section 8 of the Guardians and Wards Act 1890. This statute makes a child a ward and not an adoptive child. After the child turns 21, he or she is no longer considered as a ward and is treated as an individual identity. In Muhammad Aladat Khan versus Muhammad Ismail, it was held that acknowledgement of paternity under Muslim law is the nearest approach to adoption. Christians can adopt under the Guardians and Wards Act 1890 only from foster care, but once the child attains majority, he is free to break connections with his adoptive parents. Inter-country adoption. In India, Adoption of Children 2015 governs adoption by foreign citizens or NRIs. Under these guidelines, misuse or illegal use of the children through adoption is prevented and only children under 3 years of age can be adopted. In case of adoption of abandoned, abused and surrendered children, all inter-country adoptions shall be done only as per the Section 57 and 58 of the Juvenile Justice Care and Protection of Children Act 2015. Capacity to adopt under Juvenile Justice Care and Protection of Children Act. The prospective parents should be mentally sound, physically fit, and they should be fully prepared to adopt the child and also should be ready to provide good upbringing. In case of married couples, both the spouses' consent is required. A single male is not eligible to adopt a girl child. No child shall be given to any couple until they have at least 2 years of stable marital relationship. The minimum age difference between the adoptive child and the parents should not be less than 25 years. Couples who have 3 or more children shall not be allowed for adoption except in special need as mentioned in regulation. Who can be adopted? As per the Hindu law, following child may be adopted, namely, the child can either be a girl or boy if she is a Hindu. He or she has not been adopted before. The age of the child is below 15 years. The child should not be married. As per the Guardianship Law and the Juvenile Justice Care and Protection of Children Act 2015, following child may be adopted, namely, who is not a Hindu, who is not completed 18 years, or who is an orphan or abandoned or a surrendered child. Who can give child in adoption? Both the parents or the guardian of the child. If one of them, if either has renounced the world or ceased to be a Hindu, or in case has become mentally unsound. If both the parents are dead or not competent in law, then in that case, guardian can give in adoption with the permission of the court. Who governs the adoption procedure? CARA, that is the Central Adoption Resource Authority, is a statutory body under the Ministry of Women and Child Development of Government of India. It functions as the central or nodal body of adoption of Indian children and monitors the in-country and inter-country adoptions. Criteria or eligibility of the child to be adopted under CARA. The child must be legally free for adoption. Two unrelated children cannot be proposed to a foreign family at a time. A child can be placed in adoption before it reaches the age of 12. The child's consent has to be obtained wherever it is applicable. Adoption process in India. The parents or persons who are willing to take a child in for adoption must fulfill the eligibility, conditions and capacity to adopt. Under the Hindu Adoption and Maintenance Act 1956, they can make application to the Child Welfare Agency and get in touch with any voluntary coordinating agency or child welfare agency in their respective region or area. Registration can be done either by Adoption Coordinating Agency, that is ACA, found in each state's capital city, or an agency certified by the Central Adoption Resource Authority, that is CARA, in New Delhi. The agency will then register their particulars by way of application form. The agency will conduct a preliminary interview with the adopting couple in order to understand their intention and motive behind adoption. Next, this agency will identify a placement agency and a suitable child that fulfills the legal requirements as prescribed in the Act and the requirements of the couple's application. Afterwards, a home study report is prepared for perusal by the agency. The adopting parents will be called to meet the suitable child as identified by the placement agency. The doctor selected by the adopting parents will screen the child medically. Once the decision has been made, the prospective parents can file the petition at the court of apt jurisdiction where the court hearing takes place. The court is required to dispose the adoption case within a maximum duration of 2 months. As the court issues the decree, the adoption is finalized. Under the Guardianship and Wards Act 1890, the party seeking guardianship has to file an application to the court where they provide complete information on them, reasons behind to become the guardian of a child and other information asked in the application. After admitting the application, the court will set a date for hearing, where it will hear and view evidence requirements, and considering the interest of a minor, then the court will decide whether the guardianship of a minor should be given to such a party or not. There is a directive that adoption proceedings have to be completed within 2 hearings and the petition has to be disposed within 2 months of the filing of the petition. The certified copy of the order has to be obtained by the agency within 10 days. The agency must also contain the birth certificate of the child with the names of the adoptive parents. The agency will be guided to ensure a post-adoption follow-up also. The adoptive parents or adopted child cannot cancel the valid adoption or return back to his or her biological parents if valid procedure has been followed. However, in case of any fraud in adoption proceedings, only the court can invalidate such an adoption. List of documents that shall be required for adoption. The following documents are required for the procedure of adoption: proof of identity, which could be either the voter ID card, PAN card, driving license or passport; proof of address indicating residence in India exceeding 365 days, certificate of marriage, 3 recent photographs of the adoptive family, 2 letters of recommendation from persons who know the family well. Such type of recommendations should not be from immediate spouses. written consent of adoptive or biological children if they are above 7 years of age. Adoption is a pious act, so the people should legally perform it. It is a step to give a good and standard life to a child who really needs it, and hence the same should be done by following the procedure and law. The views expressed in this video are based upon my understanding of the knowledge and laws of this country and are explained in a simple manner so that it is easy for common people to understand. Do not forget to like the video, share the video and comment on the video. And if you have not yet subscribed to my channel, please do so. Till then, thank you. Bye. See you soon.